Hello, welcome to Business Law 1080 and our new way of learning. Remember, this is a new way of me for teaching this class. I've never done this before, and I hope it works out for us. What I'm going to do for each chapter is put the outline in Canvas, and then I'm going to put the PowerPoints. They should already be on Canvas for you, that are prepared by the publisher. And then I'm going to do a YouTube lecture, which would be similar to what I would give in class, probably not as long, because I don't get any feedback from you when we're doing it this way. And I have no way of letting you stop and ask questions while we're doing this. So if you don't understand something that I'm talking about, or you have a question, what I want you to do is to email me that question at my Macomb email, which is DEMUYNCKM@macomb.edu. And what I'll do is I'll either answer you directly, or I will try to put the answer into the next video that I do on YouTube. The link to the YouTube will also be on Canvas. I'm going to try to stick as close to the syllabus as we already have. So there's going to be 3 tests. There'll be the 3 reviews, and then I'm still working on what we're going to do for the small claims project, because I'm assuming that we're not going to be back in class before the end of the semester. So I still have to let you know about that. You might remember that the first day of class I asked you all to fill out those cards and give me a way of contacting you. What I'm going to try to do is contact every one of you individually before the next test, which I will put online on the 25th of March. That's next Wednesday. And there'll be instructions with that on how to take the test. I'm going to put the test as one document, and then I'm going to have an answer sheet as the other document. And you will have to get the answer sheet back to me. The format of the tests will be kind of the same. If you have any questions about this at all, please email me and I'll get back to you as soon as I can. There's 30 of you in the class, so it might take me a little bit of time to get back to some of you, but I will. All right, so tonight what we're going to talk about is Chapter 18, which is discharge of contracts. Now you might remember we've been talking so far about all the elements of the contracts. Remember that that's the agreement between competent parties with genuineness of assent. There has to be consideration. It's got to be legal, and it has to be in the proper form. And we've gone through all of those elements already in our chapters. Now we're coming to the time when, what happens if we have this valid enforceable contract? When does it end? And that's what we're going to be talking about tonight. Then the next chapter, chapter 19, is on what happens if it ends badly. And we'll talk about what the damages are and what the remedies are for someone who doesn't perform their contract. All right, so let's talk about tonight. How does a contract come to an end? And most of the ways that we're talking about here, the contract comes to an end, it's discharged, and the parties are maybe relatively still speaking to each other. It's not a major disaster, but every contract has to end sometime. All right, so I do have the outline that I put on Canvas that I have for all the other chapters, and that's kind of what I'm going to be using as the outline when I'm talking to you. Again, as I said, there is not any feedback on this. I will tell you that my tech support is sitting watching me right now, and he laughs at what I say sometimes. So if I'm laughing, it's because he is. But most of the time, I'm just going to go through the outline. It'll be shorter probably than when we're in class. But I'm hoping that this way you'll still be able to get the material for business law. All right, so let's talk about conditions. There are 3 different kinds of conditions that we talk about. And a condition is relating to the performance of the contract. It could be a condition precedent, a condition subsequent, or a concurrent condition. Frankly, most of the contracts that we make are concurrent conditions. That is, you walk into McDonald's, which is one of the few places still open. You walk into McDonald's, you order a hamburger, they give you the hamburger, you give them the money. It's over and it's done with at that point. You've got your hamburger, they've got the money. That's a concurrent condition. It's mutual duties, and they take place simultaneously. Okay, so let's go back up a little bit and talk about a condition precedent. A condition precedent is something that has to happen before there's an obligation to perform. Okay? Something has to happen before there's an obligation to perform. A condition precedent is one party must do something before the other party has an obligation to go ahead. Okay? In a condition subsequent, there is a contract. People already have obligations. They have to do something. But those obligations can come to an end if something doesn't occur. For example, in the book, they have a contract with someone who is doing, I think it was sports broadcasting. And part of his contract, because evidently his employer is a little suspicious about his ability to stay sober. And so in the contract, he has agreed that he will broadcast the sports, but that he will allow random testing for alcohol. And one day, the employer suspects that he's been drinking, and they ask him to take the random alcohol test, and of course he takes the test and flunks it. That's the condition subsequent. He wasn't sober. The obligation on the other side, the company that was having him promote the sports, broadcast the sports, no longer has an obligation to employ him. So something has happened that terminates the obligation. In the condition precedent, something has to happen before the obligations come out. In the condition subsequent, the obligations are there, something happens, the obligations are gone. Okay? So those are the three things talking about conditions in performance. All right, now normally, and as you'll see while I'm doing here, I drink pop while I'm talking here just like I do in class. Sometimes it's water, mostly it's pop. Okay, most contracts are discharged by performance. Performance means you did what you were supposed to do, or you didn't do what you were supposed to do. Because remember, sometimes contracts call for you to actually perform, and sometimes contracts call for you not to perform. It depends what kind of a contract that you have. Most contracts end when the parties have done whatever it was they were supposed to do. And that's most contracts. Remember, when we talk a lot about things in business law, what we're talking about are when the contracts don't work out. We're trying to get to the point where we know what would make an enforceable contract. Because even though we know chances are very good, everybody's going to do exactly what they were supposed to do in this contract, it might not work out. And you want to know, okay, what position am I going to be in if that happens? All right. So what can performance be? Performance can be doing an act, or it can be not doing an act, or it could be making payment. Could be providing goods. Could be a lot of things, whatever you agree in your performance. Okay? An offer to perform is a tender. Remember, this is one of those words that we use often in the law. They don't always have the same meaning. So a tender is an offer to perform. Okay? If what you are offering to perform is to actually do something or not do something, you have to be ready, willing, and able to do that performance. And the other side refuses to let you do it, the contract is discharged. A contract being discharged means that no one has any obligations anymore. Okay? So if you, let's say you were going to do a landscaping project, you were the landscaping company, and you have a contract with someone to plant a tree in their yard. And if this tree is supposed to be planted on May 22nd of 2020, and you go to their house on May 20th of 2020, and they tell you, no, let's not do this today. Don't plant my tree. You were ready, willing, and you had the tree in your back of their truck, so you were ready, willing, and able to perform that contract, and they would let you. Your obligation is discharged. Now remember, as I've said before, you could have something in your written contract, you could have negotiated something different, but we're going to assume that that didn't happen. So you just simply had a contract that you were to plant that tree on May 20th of 2020. You went to the house, or you're going to go to that house on that day. I know I'm a little ahead of myself. You go to the house on that day, they won't let you plant the tree. The contract is discharged. All right? With payment, it's just a little bit different. If your obligation under the contract is to pay money, you have to be willing and able to pay the exact amount of money on the exact day when it is due. You can't owe $1,000 and come in with $900 and say, okay, I'm tendering the offer. It has to be the full amount on the date that it is due. If you give the full amount of money, or attempt to give the full amount of money to the other side, and they refuse to take it, then your obligation, you've performed what you were supposed to do. So why wouldn't somebody take the money from you? Well, let's say that you say you owe $1,000, and they say you owe $1,500, and they're not going to take $1,000. They don't have to. But you're willing, you have the $1,000, you got it cash, you've got it there, you're handing it to them, and they refuse to take it. You have performed that $1,000. If later on there's a lawsuit, and it turns out that you were right, and you did only owe $1,000, then any interest or collection costs stops on the day that you were ready, willing, and able to produce the amount of money that you owed. Let's say you go to court and they win. Then you have a problem. Because if you really owed $1,500, then you owe them the money, and you're probably going to owe some interest, and you're probably going to owe some other fees. So you take a risk at that point, but if you give them the money that you owed them, then you have discharged your duties under that contract, and you no longer have any obligation. All right, if you have more than one debt, and sometimes you do, especially in business, if you have more than one debt with one creditor, it's always best to tell them where you want that money applied, because if you don't, they're free to apply that money to any debt that you owe, and that may not be what you want. So you want to specify where it goes. If you pay by check, no one is ever required to take a check from you. If you refuse to take checks, it can't be for a discriminatory reason that would violate the Constitution, but you can refuse to take checks from people. They are a conditional payment. You have not actually paid until the check clears. Most creditors, if they take checks, will take the check and give you credit from the day that they actually received the check. But it really isn't paid until the check clears. And if you pay real estate taxes or anything like that, you'll see that it's written right onto your bill that this is only a conditional payment. And if the check doesn't clear, your taxes are not paid. Okay? So when we're again looking at discharge of contracts, we're looking at for the time for performance. If your contract doesn't specify any time, and remember we've talked about this before when we talked about the essential terms of a contract, you probably want to have something in your contract about when does this contract have to be performed. Because if you don't say anything at all, then it's a reasonable time under the circumstances. And the circumstances will vary for every kind of contract. I mean, it's very different if what you're selling as melons that are probably going to spoil very quickly. That's very different from something that has a shelf life of 2 or 3 years. Doesn't matter. So you have to understand that it will be a reasonable time under the circumstances. If that's not good for you, and you want to make sure that that contract is done exactly when you said it has to be done, there's a phrase that is used in the law, and you have to put that in your contract. And that phrase is time is of the essence. It's time is of the essence of this contract. Now, sometimes it helps if you put in your contract, time is of the essence, and you put in the reason. For example, if you were having somebody deliver chairs to your house for a graduation party, which may or may not happen this year, but if you were having a graduation party for high school and you needed the chairs delivered to your house, you don't need, if the graduation party is on June 1st, you don't need those chairs on June 15th. So time is of the essence of that contract. Most contracts, time is not of the essence. It's not essential. It's not absolute that it has to be done that day. So frequently you will see contracts have the phrase in there, time is of the essence. If you really want to make sure that the court will uphold it, it's best if there's something in the contract that says why time is of the essence. And there are a lot of times when it is, like the example for the graduation party. You want the performance exactly when you say it is. You need to put that in the contract. And the phrase that you use is time is of the essence. And I certainly hope that after you leave this class you do read every contract that you sign, even if it's online. You see those words in there, then you need to understand that what you are agreeing to do is not be late. That you will do whatever it is you've promised to do, or not do, on that date, because it's very important in that particular contract. Okay, so now still staying with this idea of what performance is, we're going to look at the adequacy of performance. We have a problem with this because everybody who enters into contracts wants perfect performance. And sometimes perfect performance is very difficult to get. And, if performance of the contract is like 100% and the person does 99.9%, then they have not perfectly performed the contract. But does that mean they don't get paid at all? And that's kind of what we're looking at here. If somebody performs adequately, then they will get paid for the contract. But the other side has a counterclaim for damages for the part that wasn't done perfectly. So it's kind of like a compromise that we've come up with, because that's such a harsh rule to say that everything has to be done 100% perfectly. Maybe kind of because we don't live in a perfect world. So this often comes up in construction contracts, where there's just a little something that wasn't done quite right. Okay? And so the question then becomes, we've done a little bit wrong, does that mean you don't get paid for anything that you did right? Or does it mean that you get paid for what you did right, and maybe you have to pay some damages, some money, for what you didn't do right? And that typically is what we look at when we do this. And we look to see, did the party get essentially what they were supposed to get? If they wanted a house, did they get a house that they could live in? Is all the plumbing there? Is all the heating and cooling there? Are the rooms all there? Is the drywall there? Is all of that done? And what is undone is just a very small portion, or a very small portion that was not done correctly. Okay, so if you were the person buying the house and you got the essence of what it is you made the contract for, you're going to have to pay for that. But the part that was wrong, damages are going to come for that. And frequently what they do is they look to see, all right, how much would it cost to fix it? And how much does it reduce the value? So if you had a house, and it's like the one they were talking about in the book with the plumbing contracts where they used the wrong kind of pipes, And it would cost, I've forgotten the amounts, but like $300,000 to fix it, because you'd have to rip out all the walls, replace all of the plumbing. And the plumbing they did use was, it was decent plumbing. There wasn't any quality issues there. There was no issue that the plumbing wasn't done correctly. They just used the wrong kind of pipes. And that was very important to the other side. So what the court had decided in that case is, okay, look, this $300,000 to repair the damage in this house is just, it's stupid. We're not going to rip this whole house apart when this doesn't bring down the value of the house. It's the same plumbing. Everything is fine. It's just not the right kind. So while we might give them some minimal kinds of damages, we're not giving them $300,000 to rip the house apart. So when you're looking at the doctrine of substantial performance, you're looking to see, did they get what they made the contract for? The essence of that. Did they mostly get what they wanted? And then allow a little bit off for what was done wrong. Okay, now, sometimes it comes up that the problem with our contract is really the fault of the person who's complaining about it. Well, if it's your fault that the contract wasn't done properly, the contract is discharged. If the other side did what you asked them for, and you didn't ask them for the right thing, that's not their fault. They have performed. They performed to the terms of the contract. It's your error. It's your mistake. You still owe them the money. And that would be, for example, if you were building a fire station, you know that if you do that and you're a public utility or not utility company, you have to put out bids. You can't just go out and hire a company and say, yeah, you do this. You have to put out bids. And in order to put out the bids, you have to put out the specifications, the specs. And you put out, this is what we want, so that everybody who is bidding on it is bidding on the same project. And it is to be fair, and so you know whether or not you really have the lowest bidder. So you put out the specs and you measured wrong. And so you have this fire station that you give it to the lowest bidder. They come in, they build the fire station exactly according to your specifications, and then you go to drive in your ladder truck and it doesn't fit. Is that the builder's fault? Is that the contractor's fault? No, it's you. You have to pay your bill. You're going to have to pay for that work that was done. Their performance is discharged. Okay, there's also occasionally, and I haven't seen personally one of these contracts for quite a while, where the contract says that the performance has to be to the personal satisfaction of the other party. That's kind of a tough way if you put that in your contract, because unless you could show that the other person wasn't satisfied because they didn't have any money anymore, if it's their personal satisfaction and they're not personally satisfied, you haven't performed your contract and they're not going to have to pay. So if you were putting that in a contract for your small business, you would be very well advised to look at that very carefully and see if that's really what you mean, that it's to their personal satisfaction. Because you're going to have a long way to go. If they say they're not personally satisfied, you're going to have a long way to go to show they had some kind of ulterior motive. And it's generally the court's going to say, look, you entered into that contract, your personal satisfaction, they're not satisfied. And so they've discharged their duties, but you haven't discharged yours because you didn't come up with what you were supposed to. Okay, let's talk about then discharge by action of the parties. All right? Generally speaking, a contract can't be discharged, ended, just because one party wants to. I mean, you're entering into a contract. You're promising to do things. You have to do them. You can't just say, oh, don't feel like doing that today. It was so tough to get out of bed. I just don't feel like going and doing this today. You can't do that. That's the general rule. Now, Can you alter that in a contract? Can you put into a contract that one party could give 30 days notice that they don't want to keep going on this contract? Yes, you could do that. And if it's in your contract, then one side can get out of the contract and say, nope, I don't want to do this anymore. We're done. I'm exercising the provision in the contract. Fine. But they can't just get out of bed one day and go, oh, I just don't feel like doing this. All right? Okay. Now, there are some cases where you can rescind a contract. This is not every contract. Now, if you recall, we talked a long time ago about the FTC, the Federal Trade Commission. They have a rule, and this rule is to protect consumers. They have a rule that says that if you are solicited in your home for a contract, in your home for a contract, you have a 3-day cooling off period where you can get out of the contract. You can rescind it. And we talk about rescission in the next chapter, but rescinded means you don't go through with it. Okay, so this has to, when they come out to solicit you, and this is like frequently done for new windows in your house, some kind of project you're doing around your house where they may come out and solicit you at your home. They have to give you the paperwork telling you that you have these 3 days to get out of it. They have to give you a way of contacting them within the 3 days to tell them that you don't want to go ahead with it. The reason that we have this rule is that we don't want people intimidated in their homes. And we want them to get out of what might have been a very high pressure sales pitch. So they get a chance to think about it, to see what it is they're doing, because a lot of times if you're putting in a new roof or you're putting in windows, it's a very expensive project for you. So that's why the FTC came up with these rules, to allow you a chance to get out. Now the same is true if you're taking a second mortgage on your home. The rules regarding second mortgages, you have a cooling off period there also. If you have ever gone in to refinance your home, that's considered like taking out a second mortgage. It's the same kind of thing. You don't walk in, sign all the papers, and walk out with a check. You have to wait a couple of days before they will release the check to you. It's a cooling off period. During that time, you have the right to back out of the contract and to say, no, I've thought about this. My home is too important to me. I don't want to lose it. I don't want to risk the chance of it going into foreclosure. I've decided that I'm not going to take this money, and you have the right to do that. That's not the ordinary rule. Those are different. Okay. I hope you're kind of keeping up with me. I feel like I'm talking very quickly. All right. We also have discharge by agreement with the parties, and there's a number of different ways you could agree to get out of a contract. I'm only going to hit on a couple of them. The rest of them are outlined, though, in the book if you want to, on page, 335. But what I'm going to talk about are the ones where it's substitution of a contract. In substitution of a contract, the parties to this contract could say, this contract isn't working out for us. This isn't going the way we thought it was going to. It's not the one that we want to have. So what we're going to do is going to make up a new contract, and we're going to substitute that contract for the one that we have. That would make the original contract discharged. What you have to be very careful when you're doing that is to make sure that your new contract says that it is in place of the old contract. Otherwise, we're just going to think that it's a new contract. So you got to make sure that it says this is substituted. Okay? There's an accord and satisfaction. Again, the parties may mutually agree that something is not working out for them in their contract. And so they make a deal. That's the accord. Then the satisfaction is when you go through with what you've agreed to do. That's the satisfaction. If you have the accord and the satisfaction, it's discharged. Let's say that you have, you want to put carpeting in your house, and the carpeting that you want, when they go to order it, they find that that contract is no longer, that carpeting is no longer available. What are you going to do? Okay, so you could agree that since they didn't tell you that carpeting wasn't going to be available anymore, you're going to get different carpeting, but it's a little bit more expensive. So they say, look, just to make sure that you're happy, we will give you the new carpeting at the same price as the old carpeting. They give you the new carpeting, you pay the same amount as the old carpeting, your contract is discharged. Okay. Lastly, it could be a release. The parties can sign or a release, and a release is a waiver is kind of, we talked about before, when you were marching in the Thanksgiving Day Parade, you sign a waiver that you release them from all liabilities, and then you march in the parade. And this release is kind of the same thing. You say that you give up any claims that you might have, you give up. You're not gonna pursue any of those anymore. Okay, and that would discharge the contract. Okay, we also have a discharge by external causes, and the most important probably of these is discharge by impossibility. When we're looking at a discharge by impossibility, what we're looking to see, is this an objective impossibility or a subjective impossibility? If it's objective, means nobody can do it. If it's subjective, it means you can't do it. Well, what we're looking for is objective impossibility. Has something happened that would make it impossible for anybody to perform this particular contract? Okay, that's what we're looking for, not just you. For example, if you were going to detail my car, I made a deal with one of you that you were going to detail my car, and I was going to pay you $100 to do that. I understand that's cheap, but I was going to give you $100 to do that. Okay. While you and I are negotiating this contract, someone accidentally is out in the parking lot where my car is, and whatever they do, my car winds up burned to the ground. It's completely destroyed. Nobody can detail my car now. The contract is over. You didn't burn up my car. I didn't burn up my car. We're negotiating our contract. Somebody else totally unrelated to us burns up the car. It's gone. Nobody can perform that contract. That's objective impossibility. Destruction of the subject matter without the fault of either party. The contract's over. I don't owe you $100. You don't owe me detailing my car. I get a new car. I make a new deal with you to detail that one. Fine, that's great. That's a new contract. But our original contract, it's over. It's done with. Now, if I was the one that burned up my car, I hired another student to go out and burn up my car before I had you detail it, that would be a totally different matter, because that would be me destroying the subject matter. In that case, besides the fact I would probably be charged with arson and be in really big trouble, I would still owe you $100 because I destroyed the subject matter. Okay, if the law changes and makes it so that you can't do the work, the contract is discharged. I can't make you perform something that is illegal and not allowed to do that. If I had scheduled a party in your bar for March 17th in Michigan this year, well, you couldn't do it. By executive order, you had to shut your bar. You couldn't have my party. So, is that your fault? No. Is it my fault? No. Is our contract discharged? Yes, because I can't force you to break the law. So anytime there's a change in the law that will affect your contract, that's an impossibility of performance. All right, now death or disability. This is just a little bit different because ordinarily, after the contract is made, remember when we were talking about offer and agreement, in the offer and acceptance in the agreement part, the different rules there. After the contract is made, the death or disability of a party does not automatically make the contract impossible to perform. If it is something that does not require a particular skill, the contract could still go on. Your heirs are going to have to figure out how to get it done. If it involves a particular skill, that's different. If it involves a skill that is not easily replaceable, somebody else couldn't just step in and do the work, then the contract is discharged. But if it's a death or a disability and its performance calls for work that is not particularly specialized, somebody else can do it. They can step in. Okay, now, if the other party makes it so you can't perform, that's impossibility of performance. If they won't let you perform, you can't perform. That would discharge it. And they talk again in this chapter about developing doctrines, commercial impracticality, frustration of purpose. We've talked about these a little bit before. And they are ones that are not, they're developing doctrines. They're not still widely accepted by all of the courts. Basically, they're saying maybe a rule about people having to perform contracts perfectly and no matter what happens, it has to be absolutely impossible before we're going to excuse their performance, was really too harsh and didn't fit our standards of business practice today. The courts are still somewhat reluctant to apply this. They are well aware of bankruptcy court. But commercial impracticality is usually available only when whatever it was that was going to, you basically assumed was going to happen to make your contract, and it was beyond your control. This wasn't something you anticipated before, because if you anticipate a problem, then put it in your contract, resolve the issue there. But this would be something you probably could not have anticipated and was completely different from what you expected when you entered into that contract. The court may allow you some relief from that contract. Okay. Now, temporary impossibility. Temporary impossibility actually comes up a lot more than just flat outright impossibility. Temporary impossibility is now usually handled in the contract. There will be some kind of provision in the contract that says what happens if it's temporarily impossible. If the weather makes it so you can't do something, you only are discharged from your performance during the time that the weather stops you from doing it. And when the weather clears up, then you're expected to come back and do the contract. And that's why most landscaping companies or any of those kinds of places that are weather dependent will have something in the contract now about if the weather stops us from doing this, we will contact you, you will be rescheduled, you understand that that could happen, that that's beyond our control. It doesn't mean that they don't have to ever perform, it just means temporarily they would not have to perform. Okay? And most contracts now have something in there about that. Okay, discharge by operation of law. It's harder to do this when I have to do all the talking and I not interrupted by questions or comments. All right. The discharge by operation of law means the law is changed in some way that stops the contract from going forward. For example, bankruptcy. Bankruptcy doesn't say that the contract never happened. What it says is that you can no longer enforce it. You can no longer go after, unless in some cases you got permission from the bankruptcy court to do it, you can no longer go after the debtor. It doesn't say that they didn't owe the debt. It says you can't collect the debt anymore. All right. A statute of limit, or go after them for performance, depending on what kind of a contract this was. There is also a statute of limitations. Remember I told you one day we would get to this statute of limitations. A statute of limitations is a statute, so it's a law written by the legislatures, and it says how long you have to bring a case to court. You don't have forever. If you listen to the news at all, you know that during the cases that they're doing now with the sexual assault cases, that statute of limitations has been a really big issue, that they haven't been able to prosecute a number of charges because they happened too long ago, before the statute of limitations. The statute of limitations is different in every state. You would have to, if you were doing this, you might have to consult with an attorney. You would have to look up and find out what it was in your particular state. It is different for every kind of action. It's different in criminal laws, it's different in contract laws, it's different in tort laws. Malpractice is shorter than a general tort one. Most contracts are about 6 years, whereas tort actions might be 3 years, malpractice might be 2 years. You really need to know, but what it's saying is if it happened outside that time frame, you can't use the courts to enforce your problems. Witnesses would go away, their memories would lose. Evidence might disappear. You can't just sit on your rights and hope that eventually one day you might be able to do something about it. If you feel you've been wronged in some way, you need to take action on it now, where the other person still has a chance to defend themselves. And statute of limitations are pretty strictly interpreted by the courts. You can't just say, well, I'm only a few months past that. I'm not going to listen to that. Those are pretty strict rules about when and when you cannot bring a case that it's stopped by the statute of limitations. And of course, in a contract yourself, you can make whatever your state says is true about the statute of limitations, you can make it shorter. Now, sometimes states have consumer protection laws that don't allow you to make it too short for a consumer. They're very concerned that consumers won't have a chance to enforce their rights if they make them too short. So there might be a limitation on it that way. But other than that, business to business, then you can probably shorten the limitation in a contract. Say maybe you only have a year to bring a claim or 2 years to bring a claim that the statute says you can have 6 years to bring. So again, if you are entering into a contract, it's in writing, you need to read that contract and find out what it is. Okay, well, that's come to the end of chapter 18. It's a pretty long chapter. The next one that I'm going to be doing is chapter 19. I'm not going to put the link on it right away to let you actually absorb some of this, get some questions back to me so that I have a chance to see if I can answer them before I do the next chapter. Any questions, please email them to me. I will be contacting you either by text or by email, depending on what you put on that card the first night of class. Let's all get through this together. I want you to get as much information as you can from this course and that you finish it knowing business law. Thank you.